Welcome to the law offices of Sabrina Li. If your OPT application was denied and your motion to reopen failed, and you are now struggling to restore your F-1 student status, this video may help you.
Sabrina is a certified immigration law specialist. Only 1% of attorneys in the US can earn this recognition. If you are in a similar situation, please call 213-375-8096 to schedule a consultation with us.
An international student completing her Bachelor of Science in Computer Science applied for optional practical training following graduation in May 2024. USCIS denied the OPT application on procedural grounds tied to the filing timeline. After an initial motion to reopen was also denied, our office pursued a focused reinstatement strategy and secured full restoration of her F-1 student status. She is now enrolled in a master's degree program in computer science in the United States. OPT denials carry consequences far beyond the loss of work authorization. When USCIS denies an OPT application after a student's authorized period of stay has expired, the student may find herself out of lawful F-1 status entirely, even if she had no reason to believe there was a problem. That is what happened here. The denial traced directly back to incomplete and misleading guidance from the university's International Student Office. The student had followed the instructions she was given. The instructions were wrong. By the time the error came to light, her F-1 status had already been compromised. A motion to reopen was filed challenging the denial. USCIS denied it. At that point, many students, and many attorneys, would have considered the case closed. We did not. F-1 reinstatement under 8 CFR Section 214(2) F-16 is one of the most powerful, and most underutilized, remedies available to international students who have lost lawful status. It is also one of the most demanding to execute well. A successful reinstatement requires more than completing Form I-539. It requires a compelling legal theory, a fully developed factual record, and a presentation that gives USCIS a clear and documented basis to approve. Our office built exactly that. We prepared a reinstatement application centered on the argument that the status violation resulted entirely from circumstances beyond the student's control, institutional misinformation, DSO error, and procedural failures at the school level that no diligent student could have overcome. The application was supported by a thorough evidentiary package developed over the course of the case, refined specifically for the reinstatement standard, and strengthened by a critical fact. At the time of filing, the student had already secured admission into a master's program in computer science. Her commitment to continuing her education in the United States was not a promise, it was documented. When USCIS issued a request for evidence mid-adjudication, every concern raised was addressed with precision. The response was direct, well-documented, and grounded in the same legal framework that anchored the original filing. USCIS approved the reinstatement. Full stop. The approval restored our client's lawful F-1 student status completely. She could begin her master's program, maintain her eligibility for future immigration benefits, and move forward in the United States on solid legal footing. Everything she had worked toward, her education, her career, her future, was back within reach. This is what a well-executed reinstatement strategy delivers. Not just a form filed with USCIS, but a student's life put back on track.
If you or someone you know has been affected by a similar situation, contact the law offices of Sabrina Li at 213-375-8096 or email us at info@sabrinali.law.
Our legal team will do everything in our power to handle your case. Your American dream, our commitment.